great program for today. We are going to make sure that everything is recorded for you today, but let me go through what I know that I need to do to make sure that we've met everyone's or all of the requirements here for our presentation today. So the program was made possible by the work and dedication of some really cool people. So Bob, great program for today. We are going to make sure that everything is recorded for you today, but let me go through what I know. All righty. So the program was made possible with the work and dedication of some really amazing people today. Bob, can next slide?
Yep. It's fighting back. Sorry.
That's okay. We're honored to be working with the Champ Camp Express team that are all working in the fields of their counselors, directors, school counselor, and educators. Next slide. Champ Camp was developed to support and implement the revised SED regulations on comprehensive school counseling program requirements and are based on ASCA's national model. For the Champ Camp Express series, which is kind of cool, we're also able to provide an incentive. So those of you who attend all 5 of these programs will receive a free copy of ASCA's national model, the implementation guide. It's in his 2nd edition to complement the 4th edition of the ASCA model. So I'm excited for all of you who have attended the 3 prior, and this is your 4th. This gift and these programs were made possible through the generous funding from the Bill and Melinda Gates Foundation. One of the intentions of the foundation is to provide professional development free of charge to school counselors across New York State. And we're doing that through this presentation. It will be taped, it'll be on YouTube. But before I get started, I'd like to ask you to consider becoming a member of NISCA. You know, there's strong power in lots of people being part of our organization. So today we are going to, we have a guest speaker today, Dr. Stone. Next slide, I think you're 2 behind me.
Okay.
Bob?
Yep.
Nope, 1 behind me. We're gonna make sure that everything's made available to you. But before we get started, we've got some fun music for you as our special guest, Carolyn Stone. I am honored to introduce Dr. Stone. She's in her 26th year as a professor at the University of North Florida, where she teaches and researches in the area of legal and ethical issues for school counselors. Prior to becoming a counselor educator, she spent 22 years in public school in Jacksonville as a teacher, a school counselor at all levels. She was a supervisor for 225 school counselors, you know, one of the biggest school districts. In 2006, Dr. Stone was the president of ASCA and is in her 20th year as the ethics chair. She's an author, a guest speaker, serves the courts as an expert witness, and she is absolutely a friend of NISCA. Dr. Stone, I can't thank you enough for being here with us today. I took as less time as I possibly could. That whole introduction was about 4 minutes because I really want everybody to hear all the amazing things that you have to say. So take it away.
Kristen, thank you. Kristen's always been a bright spot. Every time I go to ASCA, it's always just such a joy when I run into the NISCA folks, Bob and Kristen and all these good folks. It's my second home. In fact, I pay taxes there, so I consider it my real second home, not just in emotion, but in the pocketbook too. So I love New York. I love what you stand for. I love the fact that I can always depend on New York to put students' best interest first. We've got some crazy stuff going on around the country. And, you know, New York's not one of them. I know you have your own issues, but New York's not one of them that's passing these pieces of legislation that are anti-LGBTQ. So pat on the back that you are protecting and paying attention to what's best for students in legislation. What I want to do in our brief time together today, I really want to talk about what's happening now. There's so many court cases that have bearing on what we do, so many laws that are directly related to what we do. But what I want to do is just take a little snapshot of the 2022 climate and what is happening recently that has impact on our profession. Well, we have to talk about the standard of care for school counselors. When we get in trouble, the first thing our lawyer is going to want to do is, before they even get into the facts of the case, they want to know who you are as a professional. Well, the 67 people on this call, you're a lawyer's dream because you're taking care of your professional development. You are showing that it matters to you that you attend to professional development. This is huge. The code of ethics matter also, your ethical codes, and what happens with your school board policy and the current laws in your state. Out of all of that is born your standard of care. And that's what you're doing today. You are protecting and grooming your standard of care. Time well spent. So kudos to you. The people that we have to worry about are not the people on this webinar, but the people who don't attend the NISCA conferences and they don't pay attention to the webinars. Reach out and bring in one of these prodigal people back to NISCA because it matters. If you ever get in trouble legally, your lawyer is going to want to know which professional organizations are you a member of. And you do not want your colleagues to ever have the word none come out of their mouth. We really need to groom and protect our standard of care. One of the things that impact our world as school counselors is that ethics and law contradict each other sometimes. My goodness, right now, that could not be, in my opinion, more true than all the years I've been in this business. Ethics and law seem to be bumping into each other with some of what is going on around the United States. What we want to know is that law is the minimum standard society will tolerate. You have to be legal. So if that school board policy that you're having to adhere to is stratifying your kids' opportunity, yes, you have to adhere to that policy, but don't sit on your hands. You are an advocate. People expect that of us. They expect us to be an advocate. So stand up and make your truths known. And ethics do not supersede law, but we try never to leave our ethical standards behind. Ethics are aspirational. We are constantly trying to aspire to not only be legal, but to also be ethical. We have spent the last 8 months or so, 9 months, working on the next iteration of the ethical standards. What happened at the Delegate Assembly when you were represented there last July? We rolled out the way of work to change the ethical standards from the 2016 to the 2022. All 50 states, yes, every single state, and New York included, weighed in on the standards from September to January. They kicked those to us at the ASCA Ethics Committee. A great group of hardworking people comprised that committee. They sat down and looked at all that came in, smoothed the transitions, and took out the redundancy, which wasn't very much. Then those standards went to the Diversity, Equity, and Inclusion Committee, and they came in with the yeoman's job of looking at every one of those standards through the DEI lens. They did a superb job of making sure that the DEI was front and center because that's who we are. The position statement members weighed in on it and the ethics committee members. Now they are out there for every single member of NISCA to take a look at. They're during the public comment period. So they are by no means a done deal. You have until April the 11th to take a look at those standards. They are yours. So you have until April 11th to weigh in on those standards. Then at the Delegate Assembly in July in Austin, Texas, I hope to see you there. This is when those standards will be blessed and put out there. Standards matter. If we get in trouble, they will be part of the court hearing, because it is the norms, the customs of our profession. So every court case I've been a part of as a witness, as an expert witness, looking at the behavior of the counselor who was the defendant. Every court case, that's why they have me there, not to interpret the law. I'm not a lawyer. They have me there to interpret the norms, the customs of our profession. So your codes will be part of any court case. One of the most complicating factors we're finding is who we are as a person, our values. We are our values. You cannot leave those at the schoolhouse door, and you are allowed to have your religious beliefs. But the cases that we've had recently, a lot of the basic problem was when counselors' values bump into parents, family, student values. Every single case that involves pregnancy or abortion counseling, values come into play. We've had a number of those recently, and we've also had, we continue to have suicide cases, even though they never find us guilty. That doesn't mean that we're not going to be part of defending our behavior in a court of law. So one of the recent court cases involves pregnancy. This case was out of your one of your neighbors in the Northeast, New Hampshire. What happened in this case? This school counselor was working with Jane and John Doe. Jane was pregnant, and they both expressed that if the parents knew, that they feared for their safety. So Jane and John Doe said to the counselor, please don't tell us that we have to involve her parents. It's not possible. We fear for our safety. So what McKegg did, she informed the principal that child was pregnant. Principal said, you must call the parents. Oh, no. We're not going to be doing that, Mr. Principal. However, the counselor ended up going to the New Hampshire ACLU, who put a gag order on the principal that kept him from calling the parents. So that gag order had the counselor's signature on it. Also, in New Hampshire, unlike New York, parents have to give permission for a child to have abortion. And in this case, the counselor also helped the student learn about judicial bypass, which means that the student could go before a judge and plead her case, and then she wouldn't have to tell her parents, and the judge would give her a written order that she could have an abortion. So here's one of those cases where, remember, we talked about law and ethical codes bumping into each other. Oh boy, an absolute perfect example of a counselor who's trying to protect the safety of a student, trying to give information that she thinks is critically important, but bumping into the law and parental rights. Parents have a right to be a guiding voice in their children's lives. Supreme Court tells us that over and over. HL versus Matheson, Bellotti versus Baird. 3 reasons why you can't equate the rights of minors with those of adults. 1, their peculiar vulnerability. 2, their inability to make informed decisions. And 3, the one we really have to pay attention to, parents' rights to be the guiding voice in their children's lives and value-laden issues. This does not mean we run to the phone and call parents, but I'm not sure it means we put a gag order on the principal either. I'm not sure it means that we step so far out of the box that we also tell a student about how to get a judicial bypass. Not necessary in New York because judicial bypass isn't at play there. But the point being, we are constantly trying to figure out, am I overstepping into parental rights? Has this child reached the limits where I can protect confidentiality? And so it's that dance we do. Child's right to privacy is given to them by the ASCA ethical standards. Parents' right to be the guiding voice as given to them by the Supreme Court. So what happened to McKeag in this case? This is why it's a court case, because she lost her job. She fought back and the ACLU of New Hampshire supported her. She was reinstated. Well, she didn't stay, she moved to Maine, but she was reinstated in New Hampshire. So you have to ask yourself, when you are working with these really heavy, value-laden issues, am I in the neutral box? Am I listening or am I pushing one way or the other? You have to be in the neutral box. We have Carter versus Hickey out of Pennsylvania. We have Arnold versus Escambia County out of Alabama. We have a number of cases that involve counselors in some way helping a student with an abortion. Yes, we are there for them. We listen, we support, but the courts have told us, stand ready, school counselors, to defend yourself that you did not coerce and you did not overstep your boundaries into parental rights. So it's a difficult situation. I would never propose to second guess McKeag. She was in the throes of it. She was the one who was looking into those kids' eyes. She knows them, I don't. She did what she thought was best on that day, but you have to constantly ask yourself, am I in the neutral box when it comes to these heavy value-laden issues? Values are not something we can leave at the schoolhouse door. You are your values and you bring them with you. And when you do, you have to be constantly tuned in. If it's rooted in your religion, such as for this counselor who did an all-call for LGBTQ students to come to a support group, but actually it was anything but. Once she got them into the support group, she berated them for being gay. No can do. Your school counseling office is not your platform to forward your religious beliefs. It is a dance we do that I'm here to help. But when it's rooted in your religion, ASCA says refrain from referring to another counselor based on your personal worldview, your ethnicity, your culture, your religion. You are supposed to be that person for whom all students can depend. So we have to work on our isms. Do you know your isms? You have to work on them. Check around with your friends and your significant others. They'll be happy to tell you what your isms are, because we can't afford to be sifting and sorting whom we're going to give services to, all students. And our moral principles are part of our new ethical codes, as they've always been. Do good, beneficence, above all, do no harm, non-maleficence. Show your justice, and that means equity, not equality. We want to make sure that when kids, justice means treating equals equally, but unequals unequally, but in direct proportion to their relevant difference. That's equity. You need more today, so I'm going to give you more today. We are promoting autonomy and independence. So one of the recent cases it underscored again, superhighway to losing your job, failure to report child abuse. This recent case happened where the counselor heard the first outcry from this student who said she was sexually assaulted by a fellow student in the school. That fellow student was the principal's relative. She went over to another counselor and she said, "What do I do? It's the principal's relative." Go tell the principal. Uh-oh. New York State does not give you discretion on child abuse. They don't say, well, if it's the principal's relative, you go check it out and make sure that the principal's okay with you calling it in. No one called it in. What happened, it ended up in court, all three of them. The two counselors turned state's witness against the principal, who lost his job and certificate. Superhighway to losing your job. As tough as these are, we have to call. We have to call. Recent case, just working with a counselor just a few days ago, and the fallout from this teacher being found to have sexually assaulted students. The fallout was the assistant principal and the associate principal suddenly disappeared from the job without a word, without anybody saying why. My guess is he knew, they knew, and didn't report. They were probably worried about the reputation of the school, and they tried to do the dance without reporting. You can't do that. So good faith reporting is assumed. You're not supposed to have to defend yourself. So when the principal wants you to meet with those parents for whom you called in child abuse, you do the backpedal with the principal, and good faith is assumed. You're not supposed to deny or affirm you made a call, even though they know, and you're not ever supposed to have to discuss an open case. So superhighway number 2 to losing your job. I bring you these cases every time I have the privilege of talking with NISCA, but unfortunately we keep getting new cases. So a couple of new cases. This one happened recently in West Virginia. She was just recently found guilty of 6 counts of mail fraud. What happened back in 2018, she changed her daughter's grades, and her daughter won $10,000 in scholarships that she didn't really deserve. So long story short, she is now 6 counts of mail fraud. This case is fascinating to me. Donna Hill, she changed her daughter's transcript and her daughter's boyfriend's transcript and put courses on those transcripts that weren't even offered in the school. She elevated her daughter's GPA by 1 whole quality point. They fired her. That should have been the end of the story, correct? Well, it wasn't. She filed a lawsuit against the district. On what grounds? Well, according to the policy of the district, you're supposed to be given due process before you're fired. That means that you were supposed to be remediated. Well, how do you think the courts, How do you think the courts ruled on this one? No, we are not remediating. If you had a knowledge deficit, a skill deficit, yes, you need to have an opportunity to remediate, but we don't have to remediate dishonesty. And we can't remediate lack of integrity. So no, you don't get your job back. And they do, the courts just don't take kindly to counselors doing deliberate, intentional, willful acts. So you can be incompetent and keep your job forever. Agreed? But when you do something that is intentional, that's the end of the conversation. We had a case out of New York where kids weren't getting the right Regents exam. All kinds of crazy stuff was going on. And this counselor kept being put on a improvement plan, personnel improvement plan, personnel improvement. Well, the heat was on him. He made another mistake. This time he went in and falsified the record. So is it another personal improvement plan or here's the door? Here's the door. Of course, it's here's the door. So when you make a mistake, own up to it. You won't be fired. This counselor out of high profile Potomac High School in a suburb of Washington, D.C. Everybody, all the relatives are piled into these two kids' homes the night before graduation, when the counselor had to call these two kids and say, I made a mistake, you're not walking tomorrow. Every high school counselor's nightmare. I know I had them, a lot of gray hairs from those sleepless nights. Is everybody on track to graduate? But she kept her job because it was a human error. You are allowed to have human qualities and make mistakes. Your district will support you, but don't cover it up. Willful, intentional, malicious, that's when you'll lose your job. So a couple of things that we've had recent legitimate educational interest, meaning that you can go into those records and read records and talk about it. Substantial interest means that you can step on kids' privacy rights if you have a reason to do so. Got a phone call from a counselor. I'm about to lose my job, but here's why I did what I did. I got a phone call. I found out that a student that she was being sexually abused by someone in the home, her stepfather. I called it into Child Protective Services and I came back to the office and told 5 other high school counselors. Now they say I'm losing my job because I stepped on student rights, privacy rights. Kids don't leave their privacy right at the schoolhouse door. When they walk through that door, they have more privacy rights than you and I do. They also have more First Amendment rights than you and I do. We just can't be talking about highly sensitive information to 5 other high school counselors in the office. She said, but I had to, because if I'm absent and this kid comes into the office, then the other counselors need to know what happened to her. No, didn't pass muster. Didn't pass muster because here's the problem. 5 other people did not need to know that highly sensitive information, not only about this child, but about this child's family. Let's say, theoretically, this didn't happen, but let's say that the counselor was getting ready to go on 12 weeks maternity leave and they were dividing up her caseload. And she called the young girl in and said, look, I want you to have the counselor you feel most comfortable with. Who do you want? Oh, you want Miss Shara? Okay, we will make sure that you get her. What do you want her to know, if anything, about your trauma? Oh, you want her to know. How do you want her to know? Is it okay if we sit down together? So those are defensible. You can defend, that is a straight line. I stepped on this kid's privacy right with this kid in mind, trying to help her get the right counselor, and that counselor now has the need to know information. So kids do have a privacy right. When you go into the lounge and you hear people stepping all over family and kids' privacy rights, it happens every day. The reason why we don't have more court cases than we have is because it doesn't get back to parents. Want to also talk about, with regards to privacy rights, PPRA. I've been asked as ethics chair for 20 years. Nobody ever asked about PPRA for 18 of those 20 years. All of a sudden, everybody is asking about PPRA. The reason, parent groups are becoming more prolific through social media. They are educating each other about privacy. More and more people are learning that you can't ask kids certain things in school. We know that FERPA is what we maintain. That's that law that blankets our school on anything we maintain on a child. Family Educational Rights and Privacy Act. But PPRA, Protection of Pupil Rights Amendment, that is what we can actually ask a student and collect from a student. Here are the 8 protected categories, and this is a whole hour presentation in and of itself. If you want to know more about PPRA, ASCA has a webinar on that that we did last summer. So take a look at that webinar if you need to know more on PPRA, but there's an awful lot of information too from the U.S. Department of Education, SPPO office, Student Privacy Policy Office. They can give you the skinny on PPRA. But we're not allowed to ask kids without written permission if it is a required survey or needs assessment. We are not allowed to ask kids about their mental and psychological problems, their sex behavior or attitudes. So if you've got if your school is like most schools right now, the mental health issues were exacerbated under COVID. You want to do a needs assessment or a survey to find out how your kids are faring under COVID. And you put in there, have you felt depressed lately? Do you feel suicidal? Those are protected areas that you would only be able to ask with parents' written permission. And we know that that's not going to happen. If you send out 500, you might get 5 back. So there are ways to do this. It's just not allowed in a survey. You're working with a child one-on-one. This does not apply. PPRA does not apply. You are allowed to ask that child, do you feel like hurting yourself, harming yourself, suicidal? You are still allowed to ask those questions. We're just talking about surveys and needs assessments. The 8 protected categories are, again, income, unless it's required for eligibility to participate in a program. This applies to private and public schools if that private school is receiving $1 of federal money. Even then, some of this applies to a private school. So if you're a private school, take a look at that webinar or go onto USDOE, SPPO website and learn more because kids have privacy rights. However, let's talk about when it doesn't apply that you have to get written permission. If you require the survey and it has a protected category, parents have the right opt in and know that when they did at the beginning of the year doesn't count. It has to be for every single survey you do, they have to opt in, meaning.
Carolyn?
Yes.
So there's a question in the chat about social emotional learning surveys that have been those universal screening tools that we've used. So one-on-one, it's okay, but you're recommending that if we're going to do more school-wide, that we first get parent permission.
Well, it depends. If you make it clear, look down at the third row. If you make it clear that it's not required,
Okay.
here is an opportunity for you to reach out and give us information about yourself. But I absolutely want you to know, students, you do not have to do this.
Got it. Thank
So
you.
if you don't require it and it has a protected category, you still have to let parents know it's happening, but they have to come to you and opt out. You don't have to go to them and get written permission. So that's the difference. If it has no protected category and it's not required, but it's generated by a third party, which these screeners often are, notice is only needed if it's generated by a third party and parents still have to be given a chance to opt out. So it is a situation where do your job, but just don't find yourself at the other end of these parents who are becoming more savvy about PPRA and raking some counselors over the coals who are well-meaning. One counselor said, I've been doing this survey for 10 years. I've never had anybody question it. Yeah, it's a different day and age now, the way information and misinformation can get around. On this note, let me just say one more thing. Climate surveys are okay. If you're doing a climate survey, such as you're not asking the student personally, are you depressed? That's personal. But you're saying, if you feel depressed, is there someone in this school that you could go and talk to? That's a climate survey, and that's fine. It's when it is about them personally, that is a protected category, or about their family. So I didn't point this out, but let me point this out. Critical number 5, critical appraisals of their family, that's a no-no. Like, are you ever afraid at home? Do you live with an alcoholic? You know, those are things that would be problematic. All right, let's move on to negligence. If you are in trouble, you most likely will not be in a criminal case because the people who sign on to webinars are not likely to commit a crime in the course of doing their job. Thank goodness. But we can be doing a darn good job and find ourselves at the other end of a negligence lawsuit. Negligence is when somebody feels they have been wronged. And we are as you well know, a very litigious society. And if somebody believes they've been wronged, they have a right to sue you. Yeah, and it could be that they could be found guilty of punitive damages for filing frivolous lawsuits. That happens. But when we get sued, it is most often involving suicide. Oh my gosh. Before I sell off into the sunset from ASCA's ethics chair, I hope that we have a tool to give you in lieu of suicide assessments. We need a tool, but we don't need to be put in the position of quantifying a suicide. There is no way that even the most trained medical staff, even the most trained psychotherapist can accurately know what's in a child's head and heart. Yet we are constantly being asked to make a judgment on something that we cannot judge. So if we get in trouble, it'll be a suicide case. The courts will not find us guilty because of causal connection. Even if they find we owed a duty, even if they find we breached that duty, they have to show that we caused the death of the child. Well, the child took their own life, not us. So the causal connection breaks the intervening variable of suicide, breaks that causal connection. But that doesn't mean they won't still sue, because what the lawyers know is that if they drag this court case out long enough, it costs more and more money for the state and the school district. And they will end up settling out of court to make the case go away. Because if it goes to court, they're not going to likely be able to find the school counselor guilty of somebody else's suicide. So let's talk about a suicide. Can we in this profession make suicidal ideation a ministerial duty, not a discretionary duty? What happens when counselors treat this as discretion, using judgment? They decide, well, I'm going to call on this one, but I'm not going to call on that one. That's where we get into trouble. Treat it like you would child abuse. You would never say to yourself, well, I'm not going to call this child abuse in because I know these parents aren't going to do anything anyway. You wouldn't do that. It's not your call. So call in suicide. Who? Parents. Call parents. Call parents. The only time you wouldn't call parents is if the parent is the absolute clear-cut reason for the suicide. Case in point, Cobb County, Georgia, counselor, principal, working with a student, suicidal. Why? As they're talking to her, stepfather sexually abusing her. They called the mother, told the mother to come get the girl and take her to counseling. They never called in to Child Protective Services the crime that was being committed against this child. Principal spent the night in jail. They both lost their certificate. They came to the school board to plead their case. It fell on deaf ears. They voted unanimously to dismiss them both because you cannot not call in child abuse. Instead, that's the only time you would not call in suicide to parents, is if the parent is the reason, a clear-cut reason for suicide. I'm not talking about the child who says, I can't get along with my mother. My mother doesn't understand me. I'm talking about clear reason why it's a child abuse or neglect case. So I've brought you the Eisel case every time I've ever talked to NISCA. So let me just make this real short because I cannot not do Eisel. Eisel is we go back to Eisel for our guidance. In the Eisel case, the child committed a murder and then killed herself. But before that, the peers told their counselor, who listened to Nicole Eisel's denial, did not call the father. So here's what we learned from that case. The judge said, look, counselors, never dismiss peer reports when it's a possible suicide. Yeah, I know you can't listen to all the rumors, but this is one you have to listen to. Why would you have negated those rumors. The judge also said, counselors, you should have known better. It's your training. In loco parentis, you're standing in place of the parent. And the judge said, counselors, the consequence of the risk is so great. Even in the face of a remote chance of suicide, that could be enough to establish duty owed. So ministerial is what he was saying. The judge was saying, no discretion, ministerial, call. This came out of New Hampshire. This was a very sad case because it pointed out that suicide assessments are problematic. The counselor did what the district told her to do, and she called the parent and said he came out low risk, so you don't have to pick him up. Counselors, please don't ever let those words come out of your mouth, low risk. How do you know? If you are required to quantify suicide, please speak your truths. Parent, this is what I know. It came from a peer. Truth is often found in peer reports. Parents, this is what I know. Your child is being bullied. That's often a trigger. Parent, tell them everything you know, but don't judge whether or not this child is really in danger. If you say high risk and you're wrong, wow, yay. But if you say low risk and you're wrong, as we've had in too many court cases, that's where the problem lies. So the 2022 ethics standards have strengthened this one. This is from 2016. But the 2022 ethics standards will say this even stronger. Never negate the risk of harm, even if the assessment reveals a low risk. Better to say to parents, not sure, your child was forthcoming, did not have enough information, wasn't able to observe, limited engagement with your child. Just make sure you don't paint yourself as knowing something that we can't possibly know. If they're 18, call parents. Doesn't matter. 18, call parents. And then we know about the tragedy in Oxford High School, where the counselor thought they were looking at suicide because they looked at this piece of paper and it was one body, deceased body, one person shot. The world is dead. My life is useless. Help me. If ever in doubt, beat a path to your administration. It might be in the future. That's what we do anyway, is beat a path to the administration. I listened to the counselor's testimony in the Oxford case, a recent testimony, and you know, this counselor thought in their heart of hearts that what they were looking at was simply, not simply, I don't mean to minimize it, but not homicidal ideation, but suicidal ideation. Varsity Blues, I'm not going to go over much on that because that's gotten to be old news, thank goodness. But what I do want to talk about is
Carolyn, before
Yes.
we move on, I just want to note in the chat, someone asked about the Columbia Suicide Severity Scale, whether using it is wrong. But what I'm gleaning is it's your interpretation as you are talking to the parent, which is most important. I don't know if you want to just address that.
Lisa, thank you. You nailed it. It really is not about, we have to use what the district tells us to use. But what you're trying not to do is give parents a false sense of security. Your child is low risk. Your child came out low risk. That's scary. We've had children who have come out as low risk, as in the McHale case, and it wasn't true. So don't put yourself in that position. I would say to a parent, I just don't know. But here's what I do know. Here's all the information I do know. And parent, that means you need to try to unpack this situation with your child. Find out what's going on. The best way to do that is 50-minute sessions for a while with a counselor. So no, I'm not saying you have to go in tomorrow and tell your district you're no longer going to do what they tell you to do. What I'm saying is advocate. There are some articles on the ASCA website that give you the information about what the medical profession is saying about these assessments. The medical profession is saying they're a coin flip. Now, they're not doing this out of the blue. They're looking at thousands of records from hospitals where people were given suicidal assessments and deemed not suicidal. They have found the low risk to be the one that is scariest. Think about that. Low risk is the one that is the scariest. So look at that. It was a recent article column, and it's on the ASCA website, and it talks about a number of medical, researchers and physicians who've looked back at 40 years worth of assessments, thousands, and they've deemed them a coin flip. There's just no predictive value. So I don't say that they don't have some value. What I'm saying is they shouldn't be used as a judgment call to tell parents something that we can't know. I'm involved as an expert witness right now in a court case where the counselor called the parent and just, it was all happiness. No, I don't think that, no, I agree with you. I think it was just, he was using words. It wasn't really a real threat. Well, it was. So let's not put ourselves in that position. All right. I am running out of time and I want to get to First Amendment rights. So I'm going to go there. Yes, Title IX and First Amendment. Title IX has, in April, Biden administration will come out with new regulations as promised regarding Title IX and LGBTQ. Please keep your ear to the ground so you can find out what those new regulations are. But basically from all they're talking about, what it will be is they will bring the protection back to transgender youth. Title IX's protection for transgender youth was removed. These two court cases have, under the former administration, both of these cases happened under the former administration's watch, but both of these cases out of the Supreme Court that's currently sitting in the Supreme Court supported LGBTQ youth to be protected under Title IX. So we have gone back to the Obama era where Title IX is now a protection for LGBTQ youth. So Bostock versus Clayton heard by the Supreme Court, and they said, transgender is about gender. Gigi versus Gloucester, 6 years in the courts. By the way, Gavin Grimm, who's Gigi, will be one of the keynote speakers in Austin this summer if you get to go to the ASCA conference. Gavin Grimm went through the courts for 6 years just trying to use the restroom that he identified with. Assigned female at birth, transitioned to male, told he couldn't use the restroom, filed a lawsuit, went to the Supreme Court under the former administration. They said, no, it doesn't. Title IX doesn't apply. So kicked it back to the Fourth Circuit Court. The Fourth Circuit Court said, yes, it does. And they went back to the Supreme Court with it, the school district did, and the Supreme Court said, no, it applies. The Fourth Circuit Court got it right. Title IX applies. So that's the current Supreme Court said, we let the Fourth Circuit Court stand. So a new day has dawned for transgender youth. Here's Gavin Grimm. And he has finally had his day in court and prevailed. And also, this is another recent finding. A Virginia teacher who refused to use pronouns and names according to a child's identity and was fired. The court found in favor of the school district. He tried to get his job back through a lawsuit. They said, no, no, no. You can't use your religion as reason for interfering with the policies of that district. The ACLU, they've worked on behalf of LGBTQ students, and the courts are recognizing that schools do not have an automatic right to out kids to their parents just because they're out of the closet at school. Coming out is a very serious business that should not be taken away from anyone, especially if they live in an unsupportive home. So stay tuned. Next month, we will have new legislation around transgender youth and youth who have been sexually harassed. All right. So as things are getting better in some parts of the country and federally, things are getting tougher with regards to our work with LGBTQ youth in some parts of the country. So here you go. You're talking about the Florida Bill of Rights. I'm sure you've heard of the Don't Say Gay bill. Well, Tennessee, Texas, and others are getting ready to pass. Georgia, Virginia, others are talking about passing the same bill. And not only that, but we also have states that are banning medical care for transgender youth, and conversion therapy is back in able to be used. This was banned years ago. We thought this one was dead, but conversion therapy in some states is back where they, in Oklahoma and Tennessee, they're considering bills to make it illegal to bar conversion therapy. All right. I am officially out of time. I apologize. I always bite off way too much and I can't get it all in. But let me just say one thing more about free speech. You've got it. Exercise it. And here's how. Okay, I'm just going to have to come back and do all these. You use your curriculum. ASCA's curriculum supports you to exercise free speech. Use your ethical codes. Oh my gosh, these ethical codes of 2022. Wow, it is full of marching orders that we can use with our administration about what we're supposed to be about. Use your job description, your accountability tools. And yes, you do not have unlimited First Amendment rights, but as long as you stay within your curriculum, unlike the math teacher who they don't have a curriculum that includes all the diversity, equity, and inclusion that we do. So use your math, use your leverage that the math teacher that they don't have. All right, thrill seekers, go forward and do good things. Niska, thank you, Bob. Thank you, Kirsten, Gloria, for allowing me to be part of this.
Yes, Carolyn, thank you so much. And everybody who has asked in the chat, yes, you'll absolutely have access to all of our resources from ASCA, as well as Carolyn's PowerPoint presentation. Can't say enough, Dr. Stone. always, great information, and, you motivate us to be better each time you come on. So thank you. Thank you.
Thank you. It's always a pleasure to be with the NISCA group, and go forward and do great things. You always do. You lead the nation in so many areas. Keep doing it.
Awesome. So you
Thank
guys,
you.
listen, we have one more Champ Camp Express. It's on May 4th. It's called It's a Wrap, end of year consideration. So I hope that you guys will sign up and help us to end this year really strong. Bob, I'm going to turn over to you. There's a lot of other opportunities for us to grow and learn.
So we have a series coming up that we haven't started advertising yet, but Carol Daher is doing a series for principals and school counselors. It's going to be during the day so that we maybe get the principals to come. And we're going to talk about regulations, mandates, and so on. It's 4 parts. It's going to be about an hour over 4 weeks. If you we are a CTLE provider. If you need CTLE credit for this event, you can let me know and I can get you that form. All of our recordings are on our YouTube channel. Check it out. And all of the Champ Camp stuff is right here on this click. It'll be noted in an email that you're going to get tomorrow. Here's our PD committee. Da, 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 da. And as always, some more information. You can always get more information at ASCA, NISCA, and NICED. And thanks for coming.
Yeah, it was so great to see so many of our NISCA executive board on this call, and just so many of you that joined us today. We can't thank you enough. We look forward to seeing you in May.
So Robert, do we just need to email you if we need the credits?
CTLE. If you need
Yeah.
CTLE, yeah, just email me.
Okay,
We'll figure it out. Okay.
thank you.
Sure.
Thank you.
Thanks, Lisa and Christy.
This was awesome.
Thank you so much.
Bye,
Good
everybody.